Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as the coordinator for today's webinar, which is sponsored by our Medical Litigation Practice Group. Today's program will provide you with practical information and examples for how to mitigate and even avoid a trend we're seeing toward lottery-sized jury awards in personal injury cases based primarily on calculations provided by economic experts from the plaintiffs. We're joined today by three of the firm's most accomplished appellate and medical liability attorneys who are on the front lines of this fight every day: Justin Hakala, Eric Raymar, and Rob Kamenek. But more about them in just a moment. Before we get started, I always like to take just a couple of minutes to provide you with some background about our presenters in the firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 150 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's medical litigation practice group includes attorneys who focus exclusively on the defense of physicians, healthcare providers, and extended care living centers who become entangled in litigation. Many of these matters include allegations of malpractice and negligence that resulted in serious injuries or death. Now let me tell you just a little bit about our speakers. And Justin Hakala is batting leadoff for us today. He is a senior attorney in Plunkett Cooney's Medical Litigation Practice Group. As panel counsel to some of the nation's leading insurance providers, he defends complex medical malpractice and product liability cases. He also represents hospital systems, medical device manufacturers, and life science companies in a diverse range of claims. He's a former plaintiff's attorney, and he now uses his prior experience to optimize the tactics and strategies he uses to defend his clients and to assist his colleagues here at Plunkett Cooney. Also a member of Plunkett Cooney's Medical Litigation Practice Group is Eric Raymar. He is an experienced trial attorney who has successfully defended his clients in high-exposure cases involving serious injuries and death. Leading insurance providers work with Eric to defend the interests of their policyholders in litigation, and he works with extended care facilities to defend claims when they arise. And lastly, Rob Kamenek. Rob is considered one of Michigan's leading appellate attorneys with some of the state's largest and most complex appellate cases to his credit. A fellow of the prestigious American Academy of Appellate Lawyers, he has briefed and argued hundreds of cases in state and federal courts. His practice includes a range of matters from insurance coverage and medical malpractice through employment and pharmaceutical liability. Rob serves as appellate and trial counsel serves as appellate and trial review counsel to some of the world's largest insurance companies. Now, just for a couple of housekeeping notes about today's program, and I promise we'll get started. As always, for the Q&A portion of our webinar, we're going to use the GoToWebinar questions tool that you can find on the navigation display. Please take a moment now to locate that window and feel free to enter your questions as they occur to you. And we will, at the end of the program, try to answer as many questions as possible. The only caveat I'd like to add to that is we ask that you keep those questions to more of a general nature. We don't want to get too specific into fact patterns and specific parties. So the last thing I'll mention is the slide deck for today's program is available in the handouts section of your display. So if you haven't done that, haven't located that yet, and you'd like to print out a quick copy of that, please do, and then you can follow along with your note-taking. So we are ready to begin. I think Justin Hakala is up first, as I mentioned earlier. Justin, please take it away.
Thanks, John. I'm used to having my video up there on Zoom screen, so if you can't hear me or I'm not coming through clearly, advance the slide or call me on my cell phone or something.
I'll send a carrier pigeon to you.
I'm going to get right into it. We're going to talk about economic damages today, and before we started this kind of process and put together the presentation, we talked to a number of our clients, a number of you all. And I heard, and I know Eric and Rob heard some of the same things, I heard kind of a common theme from everybody. And that theme is we all want to attack damages. We want to get up there and show how hyperbolic they are and do everything we can to mitigate. But at the same time, nobody wants to be in front of a jury talking about whether a CNA's effective rate should be $21 an hour or $23 an hour, and whether the plaintiff needs 16 or 18 hours of attendant care. Nobody wants to inadvertently bracket damages and walk into that argument from a plaintiff's attorney, and certainly nobody wants to either give the impression that we're concerned about damages, or worse yet, give the impression that the jury should be concerned about damages. So what you'll hear today is a number of different techniques that come from our toolbox that deal with how we attack them, and we attack them at different phases. One of the themes that I'm going to convey to you today as best I can is that you need to really start with this early. It might not be the first thing you do, but by the time you're doing a plaintiff's deposition, this really needs to be under your fingers, because there's a lot that can be accomplished if you get involved early. That opens up a lot of options for you. I'm a plaintiff's attorney by background. I spent the first 10 years of my practice before I joined Plunkett & Cooney doing plaintiff's work, and I've always thought of damages in those terms. I've always thought of a chain with several links, and as a plaintiff, you have to put together each of those links before you can present an element of damages. We'll talk about attendant care. Attendant care is a common driver of these life care plans and these damages pictures. To get to attendant care, a plaintiff has to put together each of these links. There needs to be a physician who says, yeah, this is prescribed, or an expert physician who says, yeah, this is indicated even though the plaintiff's not getting it now, so that it can be included in a life care plan. The life care planner or an economist needs to estimate the rate at which that attendant care is going to be paid, and either a medical or statistical expert will need to estimate the plaintiff's life expectancy so you know when the end point for that is. From there, you've got an economist typically who puts it all together, estimates the cost growth or the medical inflation associated with it, and reduces it to present value. All of those individual pieces has to be put together to form a chain before you ever get to that number on a blackboard. And from the defense standpoint, what that means for us is we can attack every link on the chain. They're not always easy, they're not always good arguments, but you can always find the softest one. And if you start early, you can accomplish a lot. I'll show you what I mean with an example on the next slide. Actually, a couple slides out, but before we get there, I want to kind of give you a sense of how this works. You've all seen these visual aids before. This is lost earnings capacity. It's a chart you'll see from one of the commonly used experts. I've actually put this together so we can kind of do these estimates before we ever get the plaintiff's estimate, because it's just it's just an Excel spreadsheet. There's no magic here. There are about 4 variables. The first one is the starting point, which is just the data loss. The second one is the initial salary, which is the highest amount they can justify. And then the endpoint is the third value. The fourth variable is just the wage inflation estimate, which is, we're typically seeing 4% now. A couple other things to point out here. If you look at the blow up, it's separated by past and future. There's a line here that's open. This contemplates a 2021 trial date. The values after that are reduced to present value. And as we get further into COVID shutdowns, these get modified as trial dates get pushed back, and so you'll see revisions to a lot of these estimates come out from the good folks at Thompson Econometrics. The next slide is household services. It's the same structure, except now we're not talking about wage loss. We're talking about the loss of services provided to oneself or one's family, like mowing the lawn, raking leaves, things like that. Typically, these charts are produced in a couple examples. You'll see 1 hour per day, 2 hours per day, 3 hours per day, and the testimony will be, well, we don't know how much the plaintiff was actually doing or would do in the future, but the jury can decide that and use these charts as a tool to estimate the cost and what they should award at the end of the case. The last slide is just an example. The last example here is future medical costs. These are derived from a life care plan. They are typically a little more complicated because the life care plans are more complicated. They can include one-time costs for household modifications, which you see in that third column. They frequently can include recurring one-time costs. Every 7 years, a plaintiff may need a new prosthesis, for instance. But often the biggest driver of value is that attendant care, and that's one of the things that leads to these huge numbers that we often see in the blockbuster verdicts. All right, take us to the next slide, John. Thanks. This is what we see at the end of the case. I've also included fringe benefits. You might see that in terms of pension benefits, employer benefits, other things that can be estimated. But this is the blackboard numbers that we see in mediation summaries, in closing statements, and they're the kind of things that make you uncomfortable, turn your stomach a little bit oftentimes when you turn that page and you see this in the demand. What I want to talk about is how you can attack these things, and in particular, how you can attack them before you ever get to a mediation or before you ever get to a trial and put on a witness, before you have to decide whether or not you put on an economist to rebut these things at the risk of bracketing damages or doing something else. What can you do before that? On the next slide, you'll see the first example. The earnings capacity date, you may have caught this. The plaintiff is working to 75 years old. Well, that's okay if you're an attorney. We all know a lot of attorneys who work to 75 and are doing just fine with no sign of retirement in sight. But if you're a hot tar roofer or you're a construction employee, that's a lot more difficult to imagine. Often you see cross-examinations of the economists on these points, but those are things they've heard over and over again, and so these economic experts become very slick at handling that line of cross-examination. What I always advocate, and what I've told everybody who is willing to ask me the question and listen to a tirade, is you got to start earlier than that. If you go to the next slide, you'll see a line of cross-examination. There are easy things you can do, and this is just an example question of how I often phrase it in a plaintiff's deposition. There are easy things you can do during that dep before the plaintiff has ever thought about the damages picture, before the plaintiff's attorney has probably thought about the damages picture, at least in concrete terms, and certainly before the plaintiff is prepared to testify about it. There are occasions where you get a plaintiff who is a savvy testifier, who's been prepped thoroughly, where the trial attorney shows up and he knows what to do, he knows what to tell them ahead of time, he knows how to handle this. But how often do you get to these depositions in a 7- and an 8-figure case and the associate's covering the dep, and you spend an hour with the plaintiff beforehand giving them everything they need to know to testify? Happens all the time, and when it does happen, you can accomplish stuff like this. If you just ask the question, hey, Social Security retirement's about 67, 68 years old. Were you planning on working until then maybe retiring, doing some travel? And you'll hear things like, yeah, I was really looking forward to traveling with my wife. Yeah, the sooner I could retire, the better. I tend to do this conversationally with plaintiffs, but everybody has their own style. If you think about it early, you can build this in. And then you eliminate the ability of an economist to say, yeah, this plaintiff was going to work till 75, because there's no foundation for it. Next slide, please. That one question buys you about $500,000 if you're looking at your blackboard damages. So these things, they seem simple and it's one piece of the toolbox, but they're valuable. It's very, very important to start early with it. Next slide, please. Here's another example. I saw this one about a year ago involving a birth trauma case. This is a twin pregnancy, and the plaintiff's claim is there were very premature twins who were born with the sequela, prematurity, all kinds of problems, really sad case. And the theory of the case is, had this pregnancy been managed differently, the gestation could have been prolonged, twins wouldn't have been born that prematurely, and they would have been fine. So again, this is one of those like pit in your stomach type of economist plans. The economic damages in this case in the future are reduced to a present value, and the present value is $16 million for one twin, $26 million for another twin. there are two options here, and I think the options reflect one plan which is home-based and another plan which is facility-based. But you often also see the option where it's home-based, where it's direct hired workers versus a service is hired, and it just depends who's going to manage the payroll taxes and the overhead and all that other stuff. So you often see these different options. Either way, in this case, we've got blockbuster damages, and right away we're looking at, well, what can we do today? What can we do early to mitigate? If you'll take us to the next slide, John. Buried in this very long report is this kind of sense that there is a reduction to present value. And when I was putting the slides together, I was trying to figure out how to convey that there were just pages of explanation on the methodology of how they reduced it to present value, but it was impossible to tell what was actually done. Essentially, I got the sense that they put a fund together and estimate the yield of a fund that would be paid out over time to cover all these costs, and at the end of life expectancy, the fund would be zero. So if that's the methodology, you need a number of variables filled in. You need the rate of interest, you need the rate of wage inflation, you need the medical cost inflation, and you need the reduction of present value. And they unfortunately, this economist kind of just synthesized all this stuff. And so you got a number, but you couldn't tell what was coming from where. It was incredibly opaque, and I spent way too much time trying to figure it out, because on the next slide, you'll see, if you don't already know, Michigan has a set reduction to present value statute. It's done by the court after a verdict, and it's 5% per year compounded annually. It wasn't always compounded annually, but it is now, which is a good thing for defendants. And I don't know what the economist did exactly in this case, but what I do know is they didn't do this. And so I pointed this out to plaintiff's counsel in as civil a way as I'm capable of doing, and I as surely as I sit here, get an addended plan. So on the next slide, you'll see what I got. It is a nice addendum, the purpose of which was to update the future earnings and life care plan expenses to incorporate the discount rate provided by Michigan statute. All of a sudden, we've got new numbers, and I'll summarize on the next slide. You can see that this one change reduced the future expenses, in this case, the future damages in this case, by $11 million. Now, if you're going into a mediation and you can reduce the plaintiff's credible demand, which is to say the first credible demand is always the first demand that they could actually achieve at trial. You'll always get these crazy people who will demand 10 times what they could ever obtain in front of a jury. But the first credible demand goes down $11 million. It doesn't get better than that. That's as good as a plaintiff negotiating against themselves. I haven't had to make an offer. I haven't had to put up a witness, and I've already accomplished something. But again, you got to be aware of the statute. I find, and I'll just point this out because I know there are a lot of out-of-state folks on this conference, I find this comes up most commonly in big cases with out-of-state attorneys and out-of-state experts where they're not taking into account the jurisdictional handling of damages. They're different in each jurisdiction, and it really pays to be savvy with that because, especially in this case, there's a set rate, and that changes the plaintiff's expert's ability to build in some wiggle room, to build in some kind of voodoo economics, to borrow a term Eric's going to use, to build up a bigger number. Next slide, please. I want to talk about one more example. This is kind of a case study from a case I was involved in, involving an anoxic brain injury. 29-year-old woman suffered a cardiac arrest due to postpartum cardiomyopathy. And the theory of the case was she had gone to the emergency department about a week prior with dyspnea, chest pain, and headache, and was worked up for a PE. Well, she didn't have a pulmonary embolism, but the plaintiff's attorney argued that there were incidental cardiac findings that should have been picked up and should have prompted a cardiac workup, which would have led to treatment and prevented this arrest. Unfortunately, this woman has a horrific anoxic brain injury and ends up requiring full-time care for the rest of her life. $19 million of the $25 million life care plan was for just attendant care, meaning the people who are caring for her, the CNAs, the LPNs, the nurses who see her on a daily basis. Next slide, please. You see it here. The life care planner estimated it would cost $364,000 a year to offer a life care plan. I'll give you a bonus tip. This option, they did option 1 and option 2 in this case. This one was care in the family home. Life care planners will commonly interview the family and say, hey, wouldn't it be nice to be able to provide care for this woman at home, for your family member at home? If there were money to do that, wouldn't you love to do that? Well, if you knew this family or you'd done the depositions of them, you'd probably come to the same conclusion I did, which is there's no universe where they could ever care for somebody full-time at home, even with in-house CNAs and skilled nurses. It just wasn't, the family wasn't set up to do that. But nevertheless, the life care planners will lead you there, and if nobody deals with it in the family depths, you don't have anything to rebut that. If you look at the next slide, what we find is that the lien in this case, which is frequently something we don't like to see, we don't like to see a $100,000 lien in a case because it gives the plaintiff an easy opportunity to say, boy, the medical care costs $100,000. Just imagine the pain and suffering. In a catastrophic case like this, the lien can actually be our best friend. For example, here this is a Medicaid lien, and we discover two things. First, Medicaid is covering the attendant care, which is provided at a Metalodge locally. The rate is about $7,500 a month, or $90,000 per year. On the next slide, you'll see that if you extrapolate that, you end up saving almost $15 million, over $15 million, just in the reduction of what that attendant care would cost. The dirty little secret here is, even if plaintiff recovers all this money, Medicaid is still going to be paying this. A special needs trust will be set up for the plaintiff, or a structured settlement, or some mechanism by which they can maintain their Medicaid eligibility, stay in that facility or wherever they're going to be, and continue to get those benefits paid by the state, yet they still can claim this as an element of damage. If we can use that, we can help to both impeach the plaintiff's experts. We can illustrate to the jury, look, they're already getting this care, it's being paid for, this is what it costs. Why is it that they are now asking for 4 times that amount? And again, those seeds can be planted in the plaintiff's deposition. What we commonly see is plaintiffs who are injured will bounce around several different facilities, and as their health stabilizes and as the family finds a place that they like, where they know people and like people, they'll settle. And what you can do is develop that story in the deposition, because you'll commonly hear, oh yeah, this place was terrible, we got her moved out of there, and she was having all kinds of problems, but yeah, she's much more stable now, I really like the care providers. Well, if you establish that, that testimony can be used directly to impeach the life care plan and the estimates that follow. I'll spend 1 minute talking about kind of some of the national trends here. In Michigan, we don't follow the common law collateral source rule. Instead, we have by statute a set-off for collateral source payments, with the exception of liens. Liens are not a set-off, but they're paid back at a negotiated rate. So the plaintiff typically doesn't get them, but the plaintiff's attorney will get paid for pursuing them in the form of a reduction of that lien. The national trend, we're seeing people pursuing and seeking set-offs for future payments, for special needs trusts that are being set up, and different states handle those in different ways. Medicare set-asides are also worth considering. They're not being used in liability cases, which is to say they're not being required in liability cases to my knowledge, but that's always on the forefront of a plaintiff's attorney's mind, because they're worried that they're going to have to start setting those up in all of their liability cases, particularly the catastrophic ones, just like it's done in work comp now. Finally, there's also a trend of really trying to figure out ways to tell the jury that the plaintiff will not be responsible for the future medical costs. Get that lien into evidence, put it in front of them, explain what it means, explain who's paying for it. You can't do it in every state, but you can do it frequently. In Michigan, the common refrain is, well, insurance isn't admissible. Under the rule, liability insurance is not admissible on negligence. But whether health insurance is admissible, whether government benefits are admissible, is a less certain question. There's not a lot on that now, and it's hard to say whether that will work, but those are arguments we need to keep in mind going forward, because in the right setting, it could really be watersheds. I'm going to skip over the last point I have. I have 3 more slides on life expectancy because I know Eric's going to cover that as well, but I will leave you with a couple points. One, those liens are so important, and if you look at the last big verdict that I'm aware of from the McKean firm, the biggest driver of value was attendant care, and in that case, we did not see the lien at all. It wasn't produced in discovery, it wasn't produced at trial, and it wasn't sought, because the lien is a relatively small portion of the overall damages, and it by itself impeaches the life care plan. So he just ignored it. We don't have to let him do that. It can be introduced, it can be subpoenaed, and we can use it offensively, particularly in the right cases. The key with all of these things is starting early, giving yourself options, and thinking about each link in the chain and whether and how they can be attacked. I'll turn it over to Eric. Thanks for your time, and I look forward to questions.
Thank you, Justin. Good morning, everybody. I'm going to be talking about some additional topics that kind of mirror some of what Justin just talked about. First and foremost, Justin told you about his background as a plaintiff's attorney, and the example he used with these damages is he called them links in a chain. I'm less optimistic. I always look at the damages portion of a plaintiff's case like it's a house of cards, and I like to look at it and say, how can I pull the bottom layer of these cards and watch the rest of that house fall down? And in doing so, I like to start with the economist report, specifically that starting salary. I like to determine how that economist arrived at that figure. And typically, he or she will go one of 2 routes. The first one is he or she will come to that number on his own, basically looking at tax records, W-2s, paychecks, testimony of the plaintiff to arrive at a figure that they deem to be a reasonable projection of what the plaintiff could have earned but for the injury. The second route that the economist typically uses is they'll collaborate with a vocational rehabilitation expert who more often than not is retained by the plaintiff in a given case. So with respect to that first avenue where the economist uses past income statements, typically what I've seen is the economist will cherry pick 1 or 2 years of the best earnings for the plaintiff and use that figure, average those 2 or 3 years and say, I think it's reasonable that the plaintiff would have earned this amount moving forward because whatever industry the plaintiff is in, and the economist will almost always testify to this, regardless of the occupation, regardless of the industry. They'll say, I think advertising, I think marketing, I think whatever they're in is going to be a booming industry over the next 10 to 15 years. Therefore, it is reasonable to assume that these last couple of years of high earnings would continue into the future. And I think that discounts the bigger picture. If we look at the past, 5 years, 10 years, however many we have, showing what the plaintiff had earned, that typically gives us a better picture of what the plaintiff is capable of earning and what the plaintiff typically earns. And we can use that for not only that purpose, but also we can use as much earnings history as we have to show how that earning has grown over time. And Justin talked about this. The economist will apply a 4.0 or 4.5% growth rate to earnings into the future. Well, one way we can use past earnings is we can look at the last 10 years, what has plaintiff's earnings grown at over that time? And more often than not, it's less than 4.5%, it's less than 4%. Typically what I've seen is it grows at about 2.5 to 2.8%. And, with that information, with that data, the expert economist almost always agrees that, yes, that's what the inflation rate has been. However, it's still my opinion that it'll grow at a higher rate moving forward for whatever reason they give. And usually it's a long-winded kind of pre-scripted answer that they give, but that's one area which we can start to kind of discredit the economist experts' opinions in this regard. The second avenue with respect to collaboration with a vocational rehab expert, I want to use an example that I recently had in one of my cases where the plaintiff retained a vocational rehab expert. That expert was brought in to basically testify about her encounter with the plaintiff. She sat down with the plaintiff for about an hour during a Zoom call, interviewed the plaintiff, learned about her work history, and gave the opinion in her deposition that I think the plaintiff would have worked in this occupation but for the injuries at issue. Now, the economist used that vocational rehab expert's opinion on the occupation and then the data provided by the vocational rehab expert to basically impute a starting salary into his chart, and then he grew it into the future using that 4.0%. So what I like to do at the economist deposition is commit him to the fact that he's relying on the vocational rehabilitation expert's opinions in the case. In other words, you'll say, yeah, I relied on the vocational rehab expert's report saying that the plaintiff would have worked as this occupation and the median salary for this occupation for the year 2020 is X amount of dollars. So once I get that commitment from the economist, then you can turn to the vocational rehab expert and start to attack the basis for his or her opinion. And in the example that I want to show, it involved a case where a lady in her early 30s sustained a back injury, and the vocational rehab expert met with the plaintiff, discussed her work history, discussed what she wanted to do in her career, and the underlying medical facts of the case. She sustained a herniated disc L4, L5. Plaintiff is alleging it caused a cauda equina, which now renders her incapable of sitting or standing for long periods of time, limits her range of motion, and ostensibly precludes her ability to pursue her desired career as a makeup artist. So the vocational rehab expert, after meeting with the plaintiff, put together a report where she outlined what a makeup artist makes on average. And the problem with it was the vocational rehab expert used statistics from the data from the Bureau of Labor and Statistics outlining a makeup artist in the performance and theater sector. So I went in and looked up this job occupation that the vocational rehab expert used, and then description on the BLS website talked about performing and giving makeup services within the context of theater and performance. And the majority of the jobs in this particular occupation were based out of New York and California. So it became clear that the vocational rehab expert was projecting a salary for a makeup artist based upon an occupation that really didn't match what the plaintiff was doing. In searching through the BLS data, there was another occupation titled cosmetology, and the job title is up here on the slide in front of you. That description talks about basically cosmetology and providing makeup within the salon setting, which is what the plaintiff did in our particular case. So here's the difference between the two. As you can see, the median salary for a makeup artist in the performance sector is about $75,730, whereas the median salary for a makeup artist in the cosmetology salon sector was about $27,380. When you look at past wages for that plaintiff in that case, her best earning years was about $26,000. So really, that second job description matched up more aptly with what she had been doing in the past. Now, with that in mind, it's clear that the vocational rehab expert used the wrong profession, and that sets her up for a basis for a motion to strike as the information presented by the vocational rehab expert is misleading to a jury. It's unreliable because it really doesn't represent what the plaintiff had done in her work career, and it really didn't represent anything that she had done in her work career, to be frank. Now, the economist in that case, suffice to say, used that $75,000 salary figure for purposes of his starting salary and then grew it into the future. So with that, a motion to strike the vocational rehab experts report is really essentially a motion to also strike the economist report, because once the vocab experts report is out, then the economist, the data that he relies on is no longer reliable. Now, moving ahead to, we talked about this, the inflation rate. The economist always uses a 4 to 4.5% inflation rate. We talked about past wage earnings, which show a better representation of what the plaintiff has earned in the past 5 to 10 years. This kind of gets in the minutia of it a little bit in terms of we're arguing over is 2.5% a better growth rate versus 4%. But nonetheless, it's another area to attack the expert's report and to kind of undermine the credibility of his data and what he's doing to present to a jury as to what proper earning capacity for the plaintiff was. Moving to the next slide, this talks about personal consumption. So I've never seen an economist account for personal consumption in his or her reports. It's unlikely that a plaintiff would ever ask an economist to do this, but nonetheless, it's relevant to a case because basically personal consumptions are what a person would have spent on him or herself over their lifetime. And examples include car payments, house payments, clothing, vacations, things that a person just inherently spends on themselves. And an economist will decline to include that in his report for a number of reasons. Another reason they like to give is they'll say, you know, that would be entirely too speculative to basically guess what a person would have spent on him or herself. Now, the problem with that answer is there are reliable sources out there that will project or give data relative to what a person spends on personal consumption based upon their age, whether they're married, whether they have kids, and where they live. So the economist expert saying that would be too speculative to put in his report is somewhat disingenuous, because his entire report is based on speculation to some degree. And to say that the BLS data that's available is too speculative, again, just kind of discounts some reliable sources that are out there that should be or could be presented to a jury that would show, listen, even though the plaintiff could have made this amount of money, there's pretty good data out there that suggests he would have spent a good portion of it on him or herself. So to award the family, you know, the full amount kind of puts them in a position of a windfall. Moving ahead, kind of along the same line of thinking, plaintiff economists, again, won't account for leaves of absence from work, but they will admit at their deposition or in their testimony that data suggests that a person over their work career will experience a number of leaves of absence for work, either for medical reasons or for leaves of absence from jobs and transitioning careers, or perhaps they lost their job for some period of time. And the reports never account for this. The economists will admit this. They'll say, you know, it'd be too speculative to determine how long a person would be away from their job. And again, it's a less tangible figure, but it undercuts what the report is showing us. It kind of undercuts what some of the deductions should be if we're going to try and project what a person should be entitled to in terms of, you know, economic damages in a case. Skipping ahead, John, to a couple slides here, it says household services. Justin touched on this a little bit. Michigan allows for household services damages. It's a component of economic damages, which has no cap in Michigan. So it's something that as defense attorneys, we need to be aware of and we need to combat early on in the case. And Justin had a very good example earlier where you start taking those plaintiff steps, and this needs to be right fresh on your mind as to whether or not we can start to attack this early on. And I think the best way to do that is to kind of take a step back and ask how is a plaintiff required to prove their element of damages? And if you move ahead a couple of slides, John, I've outlined some of the seminal case law on this topic where it talks about, one back, there you go. So it talks about a plaintiff, in order to prove damages, they have to prove them with reasonable certainty. Now, the caveat is uncertainty as to the amount of damages does not preclude an award, but uncertainty as to the existence of damages does. And that's kind of where we can start to combat and attack the plaintiff's component of damages. So we start to get into, would plaintiff have been performing any of these damages, or did plaintiff perform any of these damages prior to the at issue injury? And we can get that through the testimony of the family members or the plaintiff, him or herself, where we ask questions about, what was he doing before? What is he not able to do now? And sometimes you'll be surprised as to what answers you give, where they candidly will say, they weren't really doing anything around the house, but now they can't even walk around anymore. So that admission in and of itself kind of lends support to the notion that, plaintiff wasn't doing these household services that the economist talks about, the cooking, the cleaning, the lawn care, the snow removal, things like that, where we can start to undermine the entire basis of the economist's kind of projection. And if you move ahead one slide, John, the report typically looks like this, where they'll start to put examples of household services. Now, the economist will never say, it's my opinion that the plaintiff requires 1 or 2 or 4 hours of replacement services per day, but they will say, if the jury determines that these hours are required, I'm just providing them an example of what those costs will be. And if there's no underlying data or evidence in the case to support the notion that plaintiff was ever performing these household services in the past, we believe there's a basis to strike this portion of the report as it's unreliable, and there's really no basis to present this to a jury because there's nothing in the case that would show that this was even being done before. So without some underlying evidence in the case to support these elements of household services, again, it's another area where we feel like the economist report can be attacked in that regard. Moving ahead, right there, John. So again, this talks about projection of these household services. Typically, the plaintiff's economist will project them up through a life expectancy, and I'll touch upon life expectancy in a minute here. He'll readily admit that as a person ages, they typically would need some sort of assistance with household services, or there would be a decline in their ability to perform household services, but the chart doesn't ever account for this. The chart typically, if they're projecting 1 hour, they'll have it from the moment of the injury up through the moment of their expected life to end. So that's an admission you can get from the economist. Again, it's kind of the less tangible figure, because Justin had some nice figures earlier. We can lop off $1 million or $11 million. But again, this is an area of attack where they'll readily admit that, yeah, the plaintiff may have required these services regardless of the injury at issue, but I've not accounted for those services in my report. Moving ahead, John, one more slide. I want to talk about, I think this is the last topic for me, but medical necessity. So this, the economists will have this in their report when there's a life care plan involved. And this kind of is along the same lines of the example I gave earlier with the vocational rehab expert. You can get the economist to commit to the opinions of the life care planner and say he or she relied on the life care plan or the opinions of the life care planner. Then you could take a step back and you depose the life care planner. You start to undermine the reliability of the specific services in the report. Specifically, the life care planner, more likely than not, lacks the expertise or the foundation to really make the suggestions in the report. So what they need is a qualified healthcare provider to basically sign off on the report. And without that, the report is basically just an unqualified person making suggestions about complex medical questions and medical needs into the future. And I want to share an example about how we as defense attorneys can kind of undermine the life care plan. Specifically, if the life care plan has an indication that Dr. Smith signed off on this report, well, the best course of action is to go talk to Dr. Smith. And in this example, the life care plan, which was 46 pages in length, that Dr. Smith agrees and signs off with this report. Well, when Dr. Smith was questioned, he responded by saying, I only thought I was commenting on the portions of the report that applied to me, and specifically pages 9, 12, and 14. So he's really only signing off on 3 pages of a 46-page report. it was disingenuous at best to include his sign off on the life care plan as if he was signing up on the entire report. But again, this kind of undermines whether or not there's any support for the remaining 43 pages of that report. And if there's not, then the economist's projections based upon these opinions become, by definition, unreliable because there's no medical support for the life care plan, and therefore the economist's numbers are unreliable. Last point here, life expectancy. The best way to combat this is, one, you get the economist to commit that he's not a healthcare provider. He has not reviewed any of the plaintiff's medical records. More often than not, the economists don't bother looking at medical records. They're unaware of the plaintiff's specific comorbidities. And in the case, there's usually a medical expert who's willing to testify as to life expectancy. And the best way is to get that information in either through your own experts, or plaintiff's own experts will sometimes readily admit that, yes, the plaintiff's life expectancy was, for example, 10 or 15 years or 15 to 20 years beyond when he or she passed away. And if you move ahead one slide, John, I'll show you kind of a Q&A where there's this very basic question of plaintiff's medical expert. And he gave the opinion of a 15 to 20 year life expectancy. Well, the economist's report projected damages beyond that upper cap of the 20 years. So you can see that just by asking that question, we can knock off a number of years from this life care plan for household services, for lost wages, and for other damages, just based upon plaintiff's own expert, and kind of having that internal conflict between plaintiff's medical expert and plaintiff's economist expert. So with that, I want to pass along to Rob Kamenak. Thank you, everyone, for your time and attention today, and I'll give it to Rob now.
Thank you, Eric. As you can see from the slide, I'm going to talk about a particular case that deals with the lottery ticket concept in a wrongful death action. That's called Denny. Also talk about legal tools to use the information and the cross-examination that you just heard to hopefully strike the expert testimony of the financial expert. And finally, preservation. Oftentimes, I have the pleasure of coming in after the fact and trying to deal with some of these poor rulings by the trial judges. And as you can imagine, we need the tools even after the fact to attack certain rulings of the court. So with that, we'll move on to Michigan's wrongful death statute. Denny is an interesting case. It allows a category of damage that Michigan heretofore did not allow. Michigan's wrongful death statute, as you see there, lists 4 available categories of damage: medical, hospital, funeral expenses, conscious pain and suffering, loss of financial support, and loss of society and companionship. In Denny, what happened is the Michigan Court of Appeals ruled that the word that you see highlighted there, including, also opened the door for other types of damages to be awarded in a wrongful death context. And the category of damage was basically future lost wages or lost earning capacity. Now, why we call that a lottery ticket, if you think about this logically, the survivors were never going to get that money in the first place. And by allowing that category of damage, you're going to pass things from the defendant through the personal representative of the wrongful death case to survivors who never had any expectation of that. Now, that is different than loss of financial support. That's a recognized category of damage that we all understand. You need the proofs. You need to demonstrate that the decedent would have been supporting someone who qualifies under the statute. And if the decedent is no longer there, well, logically, the survivor does not have that money and there's a loss. But that does not apply to the decedent's future wages or future earning capacity. So it's a problem. And John, if you go to the next slide, please. Here's the Denny case. We have tried repeatedly through the Michigan Court of Appeals to dislodge this case. If anything, there's been a couple cases that have come down, one in federal court, a district court case, as you all know, that's a trial court decision, and also an unpublished Michigan Court of Appeals case called Langell, which is not binding, but nonetheless, they confirm the notion of Denny damages being allowed in a wrongful death case. I want to give you some real-life examples of how this can affect the value of a wrongful death case. Oftentimes, you have cases where the decedent is not providing financial support. But then again, if the survivors can recover what the decedent would have earned during the decedent's lifetime, suddenly the damages go astronomical. So we've had, I'll give you 4 examples. We've had a case involving a 2-month-old deceased infant, and the plaintiff's economist came in and said that the infant's future lost earning capacity was $7 million gross, $2.747 million present value. Now, again, before Denny, these cases, to state it bluntly, were not that valuable, but suddenly they have a high price tag. I'll give you another example. We have a stillborn case which we've dealt with, and the plaintiff's economist came in at $25 million gross. Got 2 cases where the decedent was 35 years old, and the damages increased because of the allowance of this new category of damage of anywhere from 2.5 to $1.3 million. So what do we do with it? John, you can move to the next slide, please. The Michigan Supreme Court can dislodge this, but the difficulty with that is twofold. One, we have found that the Michigan appellate system is not taking this issue on interlocutory appeal, and that means an appeal before you get to final judgment. So it may be a situation where, unfortunately, we finally do have a final judgment that allows this category of damage, and we can take this up through the Michigan appellate system as a matter of right. We prefer not to do that, of course, because then you have a judgment on the books, you have to bond it, and obviously you have larger exposure that way. The other problem is, and I know that Eric and Justin are used to me saying this term, but right now I would say that the Michigan Supreme Court resembles the People's Republic of Michigan. We've got 4-3 on the Democrats, and 2 of the Republicans are fairly moderate. So there may not be a willing audience in the Michigan Supreme Court. So what we plan on doing is approaching the Michigan legislature, and there are already efforts underway to approach the legislator. And Michigan is a bicameral system, and right now both the House and the Senate are run by Republicans by way of majority. I've testified in the legislature 4 or 5 times already on reduction of present value and other matters, and we do not believe, without being judgmental, that our present governor is necessarily going to be there for all time. So we hope to approach the Michigan legislature and change this anomaly because, again, right now in Michigan and perhaps in other states, a wrongful death case is now astronomically more valuable than it was a few years ago, simply by way of this category of damage being allowed. All right, the second thing I'd like to talk about is something that you're already familiar with, which is dauber. You've heard from Justin and Eric talking about the cross-examination and examination and the preparation you need for the financial expert, and everything from discovery to deposition testimony. But what do you do with it? Now, you clearly get it ready for trial, but I would suggest to you that the first step is whether or not you can knock out the plaintiff's financial expert under dauber. And I think you're all familiar with dauber. The general concept is that the principles and methodologies used by the expert, and here we're talking about a financial expert, must be shown to be reliable. And also, those methods and principles must be reliably applied to the particular facts of the case. That's also in your respective rules, Federal System 702, Michigan Rule of Evidence 702. We have an additional benefit in Michigan, and John's been going through it on the screen. We actually have a Daubert statute, which comes in very handy. And John, if you can flip back one screen, if you could. If not, I'll just deal with this screen. But you'll see that it's mandatory in Michigan that if there's a challenge to the financial expert's methodologies and principles, and generally the reliability of the expert testimony, the trial court, as the gatekeeper, doesn't have a choice. It must examine the opinions and the basis for the opinions and determine whether or not it's reliable. Okay, you can move forward again, John. And again, those who are familiar with Daubert know that there was a trilogy of cases that came out of the United States Supreme Court, Daubert, Kumho, Tyer, and Joyner. And the factors that John's going to go through next are just those factors derived from those particular cases. Now, I think oftentimes we believe that Daubert's more appropriate when we're talking about a personal injury case and in particular a proximate cause opinion of an expert. But I'd like to stress that it also applies to the financial opinion that regards damages. And in my view, not enough effort is given to Daubertize the financial expert. And again, we have various factors in Michigan varying from whether the opinion has been subjected to scientific testing, peer review, whether it's generally accepted in the relevant expert community, and whether I think the one factor, which is G that you see there, is one that we use very effectively, is whether or not it's relied upon by experts outside the context of litigation. The point I'm stressing, John, you can go to the next slide, please, is that when you're done with the cross-examination of the plaintiff's expert, consider the Daubert analysis. And I think that you'll find that you'll cash in oftentimes by striking the plaintiff's financial expert. Okay, next slide, John. As you can see from there, this is mandatory in Michigan. The last point you see on the screen is important. I'm a creature of the appellate world, and also what I'll get into in a moment is preservation. But too often we see attorneys try to challenge reliability at trial. Many judges will disallow a reliability challenge at the time of trial, that you have to tee it up ahead of time by way of a Daubert hearing or at least Daubert examination. Okay, next slide, John. And there's the ways to do it. Go ahead. The 5 questions to ask when you pick your expert. These are my suggestions. Too often we see that somebody comes in and unlike what Justin did and Eric did, they can't explain all these spreadsheets and discount rates and financial projections, and they lose the jury. And so if you don't have, for lack of a better way to put it, an expert who can talk a little bit of English and not just economics, you've got a problem. So I'm suggesting that one of your first questions to ask is, will this financial expert that you have, can they relate to the jury? The second one that's on the screen there, are these opinions coming primarily from the expert, or can the expert tell the jury that there's a discernible method? You talk about inflation by way of example. Oftentimes we see somebody talk about inflation on wages, and we see somebody who was a union member where they're simply not getting the type of boost on the pay that they normally have. And quite frankly, that methodology or that link, the fact that they're union as opposed to non-union, simply does not come out. And that's a Daubert challenge that you can make. Next slide, John, please. Every single Daubert hearing I've had is, the question asked is, where'd you get your facts and data? Did you get them from your attorney? It's a deadly question. Oftentimes you get the facts of the case from the attorney, but not necessarily the facts and data that underlie the opinion. So you got to be very careful in that regard when you pick your own financial experts. And of course, the fourth one there is, if your expert's not going to survive a reliability contest under Daubert, everything else is academic. So you do have to test your own expert before you go into the equation. And finally, budgetary concerns are important. So is your expert, your financial expert, willing to help you with respect to Daubert motions, willing to help you with respect to attacking the plaintiff's financial expert and the like? And I would suggest to you those are probably the 5 most important points when picking a financial expert. The last topic I have, because I don't want to go too far over, is simply the appellate perspective. You have already determined that the theme of this presentation is to be aggressive. Start early, be aggressive, go after financial damage claims. If you don't have effective cross-examination, you really have little chance at trial, but certainly on appeal, of reducing the lottery ticket type verdict. I have also found, and I know this is a judgment call with many of you, and it depends on the nature of case, oftentimes we do not have our own financial expert or economist. I understand that, and I understand there's a time and place for that, but I come at it from a different angle, and I want to share that with you. When I go back to the trial judge on remitter, and I suggest that the plaintiff's financial expert or economist figures are too high, I routinely get the response that you didn't even call your own economist or financial expert, and the remitter motion is turned down. So keep that in mind, both the front end of the case and the back end, which is the appeal. To be an expert on the obvious, if you don't make the Dauber challenge, if you do not ask your judge to be the gatekeeper, you waive the reliability issues on appeal. I already talked about the top point you see there. Finally, if I may, oftentimes you need to get a handle on the verdict forms and understand that the verdict forms are oftentimes drafted by counsel for plaintiff to reflect, and so his or her financial expert's numbers can be plugged right in. And if the verdict form is wrong, challenge it before it goes to the verdict. That's a challenge to be made with the judge before it goes to the jury. In Michigan and also in the federal system, oftentimes the financial expert's summary under the rule of evidence goes straight into the jury. And if the jury can align the summary, say, of the plaintiff's expert with the verdict form, then it's pretty easy for the jury to go ahead and transpose the numbers right into the verdict form. So take a good hard look at it before that verdict form is submitted to the judge and fight out the battles up front on that. Okay, in conclusion, because I know we're running late here, again, being an expert on the obvious, when you have damages that exceed the boundaries of reason, it should be a red flag in your own mind. And if you're wondering, by the way, where we got the title of this presentation, The Purchase of a Winning Lottery Ticket, it comes from a Florida appellate decision 2003. I wish we were invented to make it up on our own, but we did not. So with that, as with Justin and Eric, I stand ready to answer any questions.
Thanks very much. We certainly put in a lot of detail and we got it done pretty much right on time. So at this point, I'd like to remind everybody on the call, we do have a questions queue. Feel free to enter any questions that you may have. Right now, we don't have any, so you're front of the line if you want to pop one in there and give that question to the group. In the meantime, I want to remind everybody that this program has been recorded and will be available shortly on our website, which is plunketcooney.com, and you can direct colleagues there as well. Feel free to do that or revisit the content later. The handouts are also on that site for them, anybody that comes to plunketcooney.com. I don't see any questions popping up at the moment, so what I will do is just kind of head toward wrapping up because we did run a couple minutes over. Please, if you can, at the conclusion, you should have a pop-up survey on your screen, so we hope you'll take just a moment to fill that out and give us feedback. And we always ask about future topics because we love to include them in our programs and want to make sure we're staying relevant to your needs as well. So, Eric, Justin, Rob, I don't see any questions. I guess maybe you guys were so thorough in your presentation that there are no questions in the queue. So I think we ought to move to wrap things up. On behalf of our presenters today and all the members of our medical liability and appellate groups that were involved in putting this program together, we really want to thank you for taking time to be here today and have a great rest of the day.
Thank you, folks.